My name is Ari Berman. I am a senior contributing writer for The Nation magazine and the author of the new book, Give Us the Ballot, The Modern Struggle for Voting Rights in America. Well, leaders don't just govern in a vacuum. They govern based on the conditions in the country at the time and also the conditions that they're elected in. So LBJ, when he's representing Texas in the House and in the Senate, is principally concerned about his own political survival. And he can't really touch civil rights legislation for a long time because it's so unpopular in Texas. And so he doesn't vote for any civil rights bills from 1937 to 1956. Then the civil rights movement begins really with the Montgomery bus boycott in 1955, and there's pressure on the Congress to do something. When LBJ becomes Senate Majority Leader, he realizes that he has to start pushing on this front, that doing nothing is not an option. So LBJ gets behind the 57 Civil Rights Act and the 1960 Civil Rights Act, both of which are fairly modest efforts that don't really solve the problem of discrimination in the South at all, but nonetheless are an attempt by Congress to try to respond to the civil rights movement. And you see that President Kennedy is torn every which way. He's so sympathetic to the civil rights movement as president, but he's also weary of things like the sit-ins and the freedom rides, which are causing a lot of disorder in the South and challenging many of the people that he needs for political allies, because he's relying on Southern Democrats just like everybody else is at the time. So he's trying to placate the George Wallaces of the world and the Governor Ross Barnett's of the world in Mississippi. And so he's doing kind of a delicate dance. And then, once LBJ becomes president after Kennedy's assassination, we don't really know much about his views, especially on civil rights. There's a lot of skepticism of him because he is a white male Southerner. And you see that LBJ both, I think, feels strongly about civil rights, but also realizes that he has the political capital to do something about it. So first, he passes the Civil Rights Act of 1964. And then when it comes to the Voting Rights Act, he is both open to it but cautious. Martin Luther King goes to meet with him after King wins the Nobel Peace Prize in 1964, and he tells LBJ, I'm going to Selma to lead a campaign for voting rights. And LBJ basically tells King, I support you, but I can't do it right away. That we just passed the Civil Rights Act, I'm busy with all these other great society priorities, it's going to have to wait till 66 and 67. But meanwhile, LBJ is also instructing his Justice Department to begin drafting this legislation. So he's aware of the necessity for it, he just doesn't believe he has the political capital to do it. And then you have the events of Selma, Alabama, where the entire nation sees the brutality that is inflicted on people like John Lewis when they try to peacefully march from Selma to Montgomery. And that stirs the outrage of the nation like nothing before in the civil rights movement. It strikes such a deep chord among the country that LBJ realizes that he has to do something, he has to do something immediately. And so 8 days after Selma, LBJ introduces the Voting Rights Act before a joint session of Congress in very powerful terms. But it was because the administration had been drafting a Voting Rights Act before that LBJ was ready to move. So I think this was something that LBJ wanted to do, but the political circumstances also allowed him to do it very quickly and very formidably. So there was some idea of passing a constitutional amendment to end voting discrimination, but it takes forever to pass a constitutional amendment. So that wasn't feasible, especially after Selma. And the other thing was that relying on the courts was far too slow. That trying to strike down things like literacy tests was impossible in a place like Alabama through the courts because it took forever, and then you were dealing with conservative Southern judiciaries, judges who were appointed by Southern Democrats. And so there was just no chance that these guys were going to strike these laws down. So they needed to do it legislatively. And then they had to have some way to enforce what they did. And so the idea was to strike down literacy tests and poll taxes through legislation in those states where there had historically been the most discrimination. So places like Alabama and Mississippi and Georgia and Louisiana and South Carolina. They couldn't just name these states, they had to figure out a formula to cover these states, but basically they knew where the problem was. They knew they had to do it through legislation. And then they realized that they also needed a mechanism to be able to register voters so that people would feel the value of the act immediately, and also they needed to figure out a way to ensure compliance so that once you struck down things like literacy tests, states like Mississippi, Alabama, and Louisiana wouldn't just adopt a new device that would disenfranchise black voters going forward. And it's sort of remarkable because once the Voting Rights Act is introduced, it passes largely as introduced. Usually legislation changes a lot, but this basically was something that there was such strong public support for, they were able to get this tough bill through pretty much unscathed. Well, it hadn't been done in any of the other civil rights laws, and I think people who drafted the Voting Rights Act were aware of the history of this country when it comes to voting, which is during Reconstruction, there were federal troops in the South registering voters, and there were black governors and senators from states like Mississippi and Louisiana, something that had never occurred since. And once federal troops left after the disputed election of 1876, we began to see things like literacy tests and poll taxes and grandfather clauses and property requirements and a widespread climate of violence and fraud and economic and social retribution. And basically, an entire segment of the electorate that was enfranchised after the Civil War was then disenfranchised all over again. And so they realized that there had to be some way for the states to comply with this law so that the Voting Rights Act wouldn't suffer the same cruel fate as Reconstruction, where there's a flourishing of political power and then it ends. And so that, I think, was put in the Voting Rights Act to ensure that places like Alabama and Mississippi wouldn't be able to disenfranchise people indefinitely going forward. That said, it wasn't something that they thought a whole lot about when the law was passed. This was something that, as states like Mississippi began to change their voting systems after the passage of the Voting Rights Act, was something that became more of an issue, and it was something that the Supreme Court in particular said was a necessity. So it came more from the Supreme Court than anywhere else in terms of this preclearance requirement. Well, I think it was based on both necessity and constitutionality, that you couldn't name the states, but you had to figure out some way to cover them that made sense. And so it had to be targeted, and that would ensure its constitutionality. And if you expanded it to cover every state, number one, there wasn't a need for it. You didn't need Idaho to submit its voting changes. The Justice Department didn't have the ability to look over all 50 states' voting changes. They were having enough trouble just following a few southern states initially. And then the Supreme Court would say, well, why are you requiring all of the states to submit their voting changes? Where is the evidence that this is needed? And so the Justice Department could point to a very specific record in places like Alabama and Mississippi and Georgia, and they could say, here's the evidence for it. But they could also say, this is drafted in such a way that anyone could be covered. So it's not something that is explicitly regional focused. This is something that, we figured out how to identify discrimination. This is where discrimination is occurring, and so this is why this legislation is constitutional. This is why it's rational and important. And so basically, the law was drafted very much with the constitutionality of it in mind. I think that it was based largely on the Southern conservatives wanting to maintain their own political power, and their own political power was based on white supremacy. So whether they were racist or not, they were benefiting from this architecture of white supremacy that had kept them in power for so many years. And so they basically said that, well, even if Selma occurred, we could resolve this, and it's not that big of a deal, and there's nothing wrong with literacy tests. And so they made a series of arguments before the Supreme Court when the southern states challenged the constitutionality of the law, none of which the Supreme Court found very persuasive, because the Supreme Court upheld the constitutionality of the Voting Rights Act in an 8-1 decision, South Carolina versus Katzenbach, issued on March 7th, 1966, the first anniversary of Bloody Sunday, which was very interesting. There was one dissent from Justice Hugo Black of Alabama, where he basically made the traditional states' rights argument that said that the idea that southern states would have to approve their voting changes was reminiscent of Reconstruction, and that states would have to go bow before the federal government for approval. And that was something that was not really addressed that much in the oral argument, this idea of federal approval. They were mostly talking about getting rid of things like literacy tests and what that would do, but nonetheless it was something that Black himself saw would become important, and that lone dissent then really became the basis for the Supreme Court's majority opinion in Shelby County versus Holder nearly 50 years later. Well, what happens is the federal government strikes down laws like literacy tests that have been used to disenfranchise black voters for such a long time. And then they go and they, days after the law passes, begin registering voters, primarily African American voters, in very large numbers. And what states like Alabama and Mississippi are saying is that these literacy tests are constitutional and that the federal government doesn't have the power to register voters. So basically they were making an argument about state versus federal power, that the federal government had no business telling places that they couldn't use literacy tests, and that the federal government had no business coming in and registering voters. And they wanted to stop them from doing both of that activity, both the legal activity and then also just the practical political activity they were doing in terms of registering voters, both of which were incredibly important. Well, it's true that there was a huge upsurge in African Americans registering to vote after the passage of the Voting Rights Act. It's also true that it took a while for African Americans to be elected in real numbers in the South, to really form a new electorate. That took a long time. It took a long time to get enough people registered. It took a long time to find candidates. It took a long time for them to prevail in places. And there were many, many battles after the Voting Rights Act, which I detail in my book. And then the Voting Rights Act and the related civil rights legislation created a backlash among white Southerners. And people like George Wallace in Alabama exploited this. They both exploited the Voting Rights Act to register a lot of new white voters, and they exploited the Voting Rights Act to rally support for conservative white candidates and say, you don't want these black candidates taking over, do you? And so what we see after the Voting Rights Act is both African Americans registering in large numbers and beginning to get elected, but we also see a much larger white backlash to these efforts. And that takes, that really sort of shaped Southern politics for a long time. Well, I think the hope is that the law will be declared unconstitutional. But once Southern states realize that it's not going to be declared unconstitutional, they begin to exploit the Voting Rights Act for their own purposes. They use it as a tool to register more white voters. They use it as a tool to rally behind white candidates. And basically, they exploit the emerging white backlash. And so they don't like the law, but they realize that if the law is going to exist, they're going to try to use it to their benefit. So what occurs after the Voting Rights Act is a shift in terms of the political power of the parties, that African Americans and other minorities are identifying in larger numbers with the Democratic Party. And conservative white Southerners who don't like the civil rights movement are leaving the Democratic Party and joining the Republican Party. People like Strom Thurmond from South Carolina. And they're becoming power players in the Republican Party. So when Richard Nixon runs for president in 1968, he then becomes a lot more critical of civil rights laws of the 1960s and of the civil rights movement. Nixon is someone who supported the Civil Rights Act of 1964, supported the Voting Rights Act of 1965, but runs for president as if he opposed them in 1968. And he's trying to win the support of people like Strom Thurmond. And he's making a promise to those Southerners who support him that he's going to take the monkey off their backs, as one of his Southern emissaries say. And one of the ways he's going to do that is by challenging the Voting Rights Act. And if they can't challenge it through the courts, they're going to challenge it through the legislative process. So when the Voting Rights Act comes up for reauthorization in 1970, there's an effort to kill it legislatively by, as you mentioned, making it national, which seems great, but it's loving it to death, essentially. It's loving it so much that you love it out of existence, because basically there was no need to nationalize the federal approval requirements. There was no need to make Idaho submit its voting changes. And you had members of Congress saying that, requiring pre-approval in all 50 states would be like building a dam in Idaho because there was a flood in Mississippi. It didn't make a whole lot of sense, but nonetheless, that's the strategy that people like Strom Thurmond were trying to pursue.